Morning, Court. Yesterday when Attorney Ruffle started questioning you, she made a point of articulating your loyalty to Owen and the fact that you have an interest in him prevailing in this matter.
Yes, she did.
Do you stand to profit financially if Owen wins this pleading?
No.
How so?
Owen doesn't have funds to pay for counsel.
Are you being paid now?
No, I haven't been paid. Owen was able to raise some funds to pay for the transcript for the appeal, and so some funds came in for that. Short of that, no.
If there's a new trial and you represent him, will you be paid for that at this point, as far as you're aware?
There's no expectation of it.
You have made some admissions on the stand of some pretty significant failures as an attorney. I think that's fair to say.
Correct.
You've admitted to being ineffective.
Yes.
Do you stand to profit or gain from those admissions?
No, probably to the contrary.
Could those statements and admissions hurt your reputation in the legal community in New Hampshire?
They could.
Could they result in professional conduct complaints?
I suppose they could.
They could result in professional discipline?
I suppose they could.
And they have resulted in you appearing and being alleged to have been ineffective counsel in this matter?
Correct.
And you've reviewed the state's motion to recuse you, obviously.
Yes.
And part of that motion, they articulated as a basis for you to be recused was that you could defend your own interest over Owen's, correct?
That was in that pleading, yes?
You consulted with ethics counsel.
Yes.
And you consulted at length with your partners at various points during your representation.
Yes.
And I believe you stated on cross-examination by Attorney Ruffle that your failure to take action during the trial once you realized there were issues was ineffective.
Yes.
As part of the discovery that you were provided pre-trial, and Attorney Ruffle made clear that there were a number of things that you were provided.
Correct.
Among the things that you were not provided, I want to talk about that very briefly. Were you provided with the captures of the student email boxes?
I don't believe so. I don't think we had full access. My recollection is that we did not have the full access to those email accounts until we had received Attorney Carney's file. That's my best recollection of that.
So had you reviewed those in any event before trial?
No. So that's one of the reasons why I can't say 100% I was not. I certainly didn't look at them or review them pre-trial. So I can't say 100% that I didn't have them, but I know we didn't look at them.
I want to speak briefly to the Duncan Norton email, which Attorney Ruffle addressed on her cross-examination. Why was that relevant in your review? Do you know which email I'm referring to?
Yes.
Can you articulate why you believe that was relevant?
Well, let me answer first. There were two Duncan Norton emails. I think there was one where Mr. Thompson, Ms. Prout, and another girl were on the email. Then there was just the one between Ms. Prout and Mr. Duncan. Or Mr. Norton, sorry.
That's okay. In speaking about the one between Ms. Prout and Mr. Norton.
Okay.
Not the secret snuggle email.
Okay.
Why did you believe that was relevant?
I believed it was relevant for two reasons. One, regarding her testimony of how she had previously responded to senior salutes, to impeach that. And the second issue was regarding after the door was opened to prior sexual experiences, or that the door was open to explore that area. Again, I don't know what happened between Ms. Prout and Mr. Norton, but it was an area of inquiry.
And fair to say that document could have been used for impeachment on a specific and discrete point.
Correct.
Attorney Ruffle also drew your attention to 1J, 1K, and 1L, which I will refer to as the Wells and Thompson communication, the email chains, and then Facebook exchange. And Attorney Ruffle spent quite some time going through the conversation about them at camp and the giggling and the smiley faces. Did you consider any of those documents in isolation when you reached the conclusion that these two individuals may have had a sexual relationship?
No, I think I read it all as a whole regarding a way to piece together what their relationship was. There were email communications the month earlier, and there were the Facebook communications the month later. And I think when you read them in conjunction, you get a flavor for the relationship.
And you stated on cross that there was an abrupt end to that communication and that Facebook chain after a meeting with the police. Can you elaborate on that for the court, please?
My recollection is, date-wise, partly based on Facebook, partly based on police reports, was that immediately after Mr. Thompson, my best recollection was that immediately after Mr. Thompson was called into the Concord Police Department and questioned, he then immediately sent that email to Ms. Wells saying, "Geez, it's been nice being your friend. Take care."
And
Paraphrasing,
obviously. Paraphrasing. And my recollection is that there were references in the police report from Ms. Wells' mother saying that was an attempt to distance himself from Ms. Wells. Is that accurate?
I think Ms. Wells' mother had called the Concord Police Department, and her phrase, based upon my recollection on the police report, was that she saw it as Mr. Thompson attempting to reframe his relationship with her daughter.
Attorney Ruffle questioned you about the line of testimony with Mr. Thompson opening the door to prior bad acts of Owen. You're aware of Rule 404B?
I am.
And you're aware of the pre-court rulings in this the pretrial rulings on pretrial motions in this case?
I am. I mean, I can't tell you verbatim what all of generally, yes, I remember what the pretrial rulings were.
How would, as an attorney, a misrepresentation about a relationship between Andrew Thompson and Elizabeth Wells have opened the door to the information that the state was in possession of about the relationship that Mr. Labrie had with Elizabeth Wells? How would that open the door to that?
I don't know. I don't see it. I don't see it at all.
When you received that email from Sam with the jury instructions, and at this point you've recited the content and the casual nature of the call in that email, Attorney Ruffle indicated that you didn't tell them that you were unprepared to be relied upon at that point.
Correct.
Were they asking you if you were prepared to be relied upon?
I didn't think so.
Did you believe you were being relied upon?
No, I didn't think I was being relied upon.
If you had believed you were being relied upon at that point, would you have said something?
I would have been more clear. If at any point they had said to me, "You're in charge of these jury instructions, we're relying on you to review them, make sure they're accurate, change them, add to them, you're kind of the final reviewer," I would have said, I don't think that's appropriate.
And Attorney Ruffle spoke to your interrogatories that I believe, and this is my paraphrase, you paid no special attention to the computer charge.
That was what she said, yes.
And she shared with you an email in which you make reference, I believe it was the email attached to the jury instructions, speaking about, I believe it was the omission language that was in the proposed instructions. Do you recall that?
I think she was referring to I made a comment in my response email to Attorney Zegangori as it related to the computer charge. I said something about the penetration requirement, but I did make a statement about an emission issue in another instruction that related to another charge. One of the sexual assaults maybe, or something like that.
Was the information that you provided in that response email correct?
No, I was wrong on 2 points, actually.
Was it legally correct?
No.
And was it legally incorrect in your opinion, or was it, in comparison to the law, inaccurate?
In comparison to the law, my response to Attorney Zagangori was incorrect.
Did you draw that to their attention?
Yeah, at some point, so I think there was a follow-up email. My recollection is that Attorney Zagangori sent me the instructions. About 20 minutes later or so, I sent him my response saying, I took a quick look, here's some thoughts. And then I think he responded again and actually pointed out that I was incorrect and said, and pointed to the statutory references, and said, well, this statute requires this and this statute requires that. That was like later that night. I don't know that I saw that email that night. I might have saw it the next day, actually. But, at some point he recognized my failures, to be accurate.
Did they correct the instructions?
I don't think they made any changes to the instructions. I don't know, because I don't know what the final version, I haven't, or I probably have them in the file, so I can't say I don't know what they are. I've never done a comparison to what I was sent in that email from Attorney Zagangori and the final instructions that were given. But based upon my recollection of what happened in that Chambers conference, I don't think there were any changes made. I think what Your Honor had originally proposed and was reviewed by counsel was what ended up being the final instructions.
Attorney Ruffle challenged you on your suggestion that a nullification instruction may have been relevant for this case.
Correct.
Based on the fact, or her statement, her opinion, that nullification as articulated would contradict the theory of the case.
That was what she said, yes.
Did you know the theory of the defense at the time that you made the suggestion of a nullification instruction?
Well, based upon what I heard in opening, but not based on anything else. So I had some understanding.
And had you known in the anteroom during that DNA conversation all that you know now, would you have spoken up to the judge and told him that the train was off the tracks?
Yes. It's really hard in a moment to decide what is best sometimes. It's not an easy job being a lawyer. It's not an easy job being a criminal defense attorney. And it's not an easy job dealing with a personality like Attorney Carney, quite frankly. And, I made a split-second decision based upon what I thought was right in the moment. And I think that decision was wrong. I mean, I'm not going to defend it at this point. I'm not going to try to dance around it. I can explain it. I can explain what was going on in my mind and why I made the decision I did. But it was wrong. And that it is what it is. And if I could do it over again, I would have done it differently. But I can't.
Fair to say that you didn't have access to everything now that shows you the failures when you made that decision in the anteroom? That's
true. I didn't know the extent of it in that room. I mean, I could see that there were problems and that something was not going well because I had specific information of what particularly they were not prepared for at that time in that room. The full extent of what I thought was their unpreparedness, what I think was their unpreparedness now as I sit here, is much more extensive than what I understood when I sat in that room during trial, if that makes sense.
It does make sense. Thank you. You violated your duties as local counsel.
I think I did.
And you broke the rules.
Yep.
As established by Attorney Ruffle on her cross.
I did. I think when you make a mistake as a lawyer, all you can do is own up to it.
Thank you. I have nothing further to say.
Any recross?
No problem.
Thank you, Ms.
Thank you.
Judge, I would ask that Attorney Raincourt be excused from the courthouse, but that she remain under subpoena and under sequestration in case we need her for rebuttal.
I have no objection.
Okay.
I
That means she
agree that she
continues to
needs
be
to be-
subject to the sequestration.
Yes.
order.
Correct, Judge.
Yes. Thank you.
Thank you. Judge, the defense would call Rebecca Dixon. Judge, can I approach the clerk just to check the exhibits really quick?
Sure.